Okay, welcome back, ladies and gentlemen. I'm Joe, he's Nick, and you are listening to the Nick and Joe Show live. Well, not necessarily live, because you could be listening to us on the podcast.
That is true.
From the Think Radio Broadcast Centre in Ottawa, Canada's national capital city. Okay, I think it works that way.
Yeah, that works.
National capital city.
There you go.
And last hour, the last two segments, we've been talking everything Winston Churchill, and I think we've worn that subject out for the time being. Nick?
Well, we'll give it a breather.
We'll give it a breather because, I guess you can't really wear out it.
No,
there's just too much ground to cover. But
that's right. However...
Okay, so let's shift gears a little bit, get into some controversy, because we like controversy.
Oh my God!
And so we have a couple of things we want to talk about for the rest of the show, for this segment and the next segment, and that is let's start with just looking here at my notes. Thespians, backyard thespians. That's quite a word, isn't it? I feel like Churchillian when I use that term.
He would have been
thespians.
considered no, he wouldn't be a thespian. But
I don't know. Anyway, so here in Ottawa, it's a family or a group, Nick? Is it?
Let's see. Let me just share some of the article, and that might tell us what we want to know.
Okay, Nick's going to read to you from the article.
In an apparent zoning issue, the city of Ottawa is shutting down a youth theatre troupe backyard performance of Shakespeare. The group of young thespians who call themselves Company of Adventurers have been rehearsing Shakespeare's A Comedy of Errors in an old Ottawa South backyard. The performance will not go ahead in September. The troupe planned to take donations for the food bank. The Company of Adventurers told the news agency that they had rules in place to make sure they could comply with COVID-19 regulations. The small crowds would have been reservation only and would be spaced out. Ultimately, city bylaw stepped in to shut down the planned performance. The reason the backyard is not zoned for performance. When I heard the news, I was kind of shocked because this has never happened before in all the years I've been doing this play. Performer Paula Selskew told the reporter. Okay, that's really as far as we need to go. Like, I don't care what the city's reaction was. First of all, my first point about this is, what business is it of the city's through its bylaw agency? Like, how do you define a performance? Like, I just spent the long weekend with my family. Okay, there we had all 8 kids, all the fiancés, a couple of cousins. There was about 21 of us or so. And at night, we would gather on the campfire, and we would sing different songs. Campfire songs. Is that considered a performance? If this had happened in Ottawa in a backyard because it's private property, and we wanted to have a family, we weren't rowdy, we weren't boisterous, we weren't setting off fireworks or anything. We were just enjoying each other's company and doing something we all enjoyed. So that's number one. How do you define a performance? And secondly, why is it any of the city's business if there's a performance going on private property in the first place? They're not quoting COVID here. They're not saying it's because we're afraid of this dread disease. They're saying it's not zoned for that. Well, I don't care. It's not your business to tell me what my backyard's zoned for. If I want to have people over and have a barbecue and somebody break out a guitar and do some music, or somebody recite a poem, or put on a little play, who the hell are they to tell us that we can't do that?
Nick's a little passionate about this.
I am thoroughly pissed at this because this is an intrusion by the state, your royal word state here, into people's private lives they have no business getting involved in. It's obviously I'm not the one in charge, because I'd have told that bylaw officer what to do with his ticket and where to stick it, and he'd better get off my property right now, or I would be calling the police about criminal trespass charges, and I'd see him in small claims court because you could sue those guys.
Yeah. Well, generally speaking, I'm with you. But of course, the question becomes, if you're in the city and you have a backyard, and I want to emphasize before I get too far down this road that I'm not defending the city here, but I'm playing a little bit of devil's advocate. I don't agree with the city's approach to this, but let's just take it a couple of steps further. Let's say you have a backyard and you decide that you want to start a playhouse. So you're going to put up stands in your backyard and a stage, etc. Your position would be no problem. Go right ahead and do it.
As long as I am not disturbing the peace of my neighbors, then no problem.
Now, what if your neighbors were disturbed by it?
Well, then they can come and talk to me first. And secondly, if they're going to file a complaint, they can't do it anonymously.
Right.
Have the courage to stand up and say, look, I find this I work shift work, because most people are reasonable.
Right.
They're not going to give us a hard time about if somebody says, look, man, I got to be to work for midnight. Can you tone it down? Or could you do it on another night or something like that? I would like to think most people say, hey, man, we didn't know. Of course. Well, let's see what we can work out here. They're reasonable.
Right. Well, I actually think that it's, the state doesn't have a place mediating between neighbors when they have a conflict over whatever's going on in one another's properties. I think that that's something that people should work out themselves. And if there is grounds, if there's a conflict and somehow or other it needs to be adjudicated,
that's what small claims court is for.
Take them to court.
That's right.
And there are barriers to people going to court for such a thing. But I think that what's happened, Nick, is that rather than going to court, what we've done is we've created these laws and bylaws that are intended to take the place of the adjudicatory system, and we pass laws basically saying this is how you're going to act to one another, and as a consequence of that, people don't have the capacity anymore to talk to one another and work out their differences. Basically, if your neighbor's got a loud party, and as you say, you have to get up the next morning, so maybe go knock on the door and say, can you tone it down a little bit, turn it down. And you know what? With my neighbors over the years, I've done this. They've had parties, or there've been loud, rowdy stuff going out in the front. You know where I live, and and I've had to go out and say, guys, I'm not begrudging you to have your party. You have your party. You have a couple of beers. I don't even care if you're drinking your beer out in the front lawn or whatever. Doesn't matter to me. What matters to me is my kids are trying to sleep, so you have to turn the volume down. And my experience with that is that they do. I've never had a situation where I've had to go to a neighbor or even strangers who are attending a party at a neighbor or some other function. I've never had a problem where they've said, jump in the lake, I don't have to listen to you. Who are you? The thought police, the noise police, et cetera, et cetera, et cetera. So my experience has been very positive, with one exception, and that was there were some drunk guys actually fighting out front.
Okay, that's different.
In that case, it was okay. Well, I think we better call the police, have the police, because this is getting. That was a New Year's Eve party, and it was getting really out of control.
Yeah. Okay. Fair enough.
So I'm with you, Nick. I'm with you on this, but I said I was going to play a little bit of devil's advocate, and I'm going to, because all of this raises the question: at what point in time, once you've decided that there is a zoning law, at what point in time does the state or the city decide that you are violating the zoning laws by having this playing in your backyard? In other words, is it if I have 10 people came to listen, if I have 20, 25, 50, or is it if I charge admission? Like, how do you decide when the zoning law applies and when it doesn't? Okay, because common sense, you'd go, okay, if the kids are getting together and putting on a play for their friends, you're not gonna call the bylaw, and they're gonna. But technically speaking, that might be a zoning violation, and it might be against the law. So actually what I'm doing here is I said I was playing devil's advocate, but I think I'm probably illustrating your point a little more effectively.
You notice I'm not saying anything.
Yeah, it's a really tough thing, and I don't know what the specifics of the bylaw here are.
Joseph, the best way to solve this is this. First of all, if one neighbor calls a city complaining with a complaint about the other neighbor, here's the city's response. Go talk to him. If you can't come to terms, see him in small claims court. We do not get involved in neighbor-to-neighbor disputes. Have a nice day. Click.
Right.
End of story. That way, the individual making the complaint has to have valid grounds for making the complaint. Because I agree with, look, if I had 150 people and, 4,000 watts of sound pumping out of my backyard, okay, I'm going to annoy the neighbors. But you got to live in that community. If you want to be a complete jerk and have all your neighbors hate your guts, then you're not going to care. But they have recourse. That's what small claims court is for.
Partly,
so,
yeah.
And you can take them in there. It costs you about $80 to register, and you can sue them for up to $25,000. So if you wanted to say, look, man, you either tone it down or we're going to see each other across the, in the courtroom because I got work to do in the morning. My kids got to go to school,
right.
And you're way over the top here.
Right.
Okay, and most people can work that out.
Right. But
the city has no role.
I could be wrong here, Nick, but I think that probably most of these types of complaints aren't necessarily because of the noise or what's going on in the backyard. But, and again, I'm not taking issue with what you're saying. In fact, I'm supporting it. A lot of times you'll get neighbors, anonymously complaining to the city because, your neighbor has an RV parked out front for 3 months in their laneway, and a relative happens to have been living in it while they're visiting, rather than paying for a hotel, etc. So, is that a bylaw violation? Well, I think it is. If it's bothering you, what do? You end up calling the city and squealing to your neighbor.
So the city as your bully.
I know of a few cases with the back in the landowner days that there were times when somebody had a fridge on their front porch, which was unsightly.
I remember
that. Or they weren't cutting their grass once a week. So you pick up the phone, you make a complaint to the city, and the city comes and it becomes then a dispute between you and the city. And there's a big downside to this, other than what we've been discussing in terms of the breakdown of relations between neighbors and the ability to mediate between one another and to work these things out, which is a skill. It's something that you should have the ability to do. But one of the really big downsides of all of this is that if bylaw enforcement comes and they say, okay, this is not a violation, then you don't actually have recourse anymore, because I could say, well, what I'm doing is perfectly legal, because the bylaw people came around and they looked at it and they said, okay, there's not a problem here, so I can continue to have my parties out on the front porch with my beer fridge, okay, and now the neighbor that this is irritating no longer has any recourse, because they can't go back and say, well, I'm going to take you to small claims court because you're bothering me, because what you're doing is perfectly legal.
But this is why the city has no grounds, should have no foothold in this case,
right?
So that it has to be between neighbors,
right?
And they both have recourse, because if they both take their complaint to court, take your beer fridge example or your RV example, which the RV one really puzzles me, like who would care? I don't know. But anyway, unless you run a hotel, and even then, look, you're never going to get everybody staying at your hotel anyway. So
well, why can't I run a bed and breakfast out of my house?
Yeah, that's a good question. You should be able to.
I'm not violating anybody's peace of mind.
That's right. You should absolutely be able to. But
it's not zoned that way.
I understand that. And
right.
That's another part of the whole problem, is we've let the state dictate to individuals how those individuals will behave, instead of the individuals dictating to the state how they should behave. And that's a big problem. So, again, you go back to the argument. My argument would be keep this, and by state, I'm talking the Royal